Tantor Audio, a division of Recorded Books, presents The Legal Analyst, a toolkit for thinking about the law, by Farnsworth, narrated by Sellon-Wright. Publisher's note: in this audio edition, you will hear references to visual materials present in the print and e-book formats of the book. Preface. This book is a collection of tools for thinking about legal questions. It attempts to gather the most interesting ideas one learns about in law school, or should learn, or might wish to have learned, and explain them in plain language with lots of examples of how they work. The result is a kind of user's guide meant to be helpful to a wide range of people: law students, lawyers, scholars, and anyone else with an interest in the legal system. An alternative title for the book, Thinking Like a Law Professor, might have been more descriptive, but was rejected by the focus groups as ambiguous, as it might be construed as a threat rather than a promise. That is a short account of this book and its purpose. A more detailed one has to begin with the way law usually is taught, which often seems to me to be upside down. There are, in general, two sorts of things one learns at a law school. First, there are lots of legal rules, principles that tell you whether a contract is valid, for example, or when people have to pay for accidents they cause, or what the difference is between murder and manslaughter. Second, there are tools for thinking about legal problems. Ideas such as the prisoner's dilemma, or the differences between rules and standards, or the notion of a baseline problem, or the problem of hindsight bias. Some of them are old matters of jurisprudence. A larger share have been imported into the law schools more recently from other disciplines, such as economics or psychology. In either event, these tools for thought are by far the more interesting, useful, and fun part of a legal education. They enable you to see more deeply into all sorts of questions, old and new, and say better, more penetrating things about them. The problem is that law schools generally don't teach those tools carefully or systematically. One might imagine it otherwise. Law school courses could be organized around tools rather than legal subjects, so that in the first year, everyone would take a course on the prisoner's dilemma and other ideas from game theory, a little course on rules and standards, a course on cognitive psychology, and so on. And in each of those classes, one would learn along the way a bit about contract law, a bit about tort law, and a bit about all the other major subjects. But instead, law school is carved up the other way around, by legal topics, not by tools. There are courses on contract law, on tort law, and on all the other topics that become familiar. Tools for thought are then mentioned here and there while those subjects are studied. Law tends to be taught, in other words, as if legal rules were the most important things one could learn, and as if the tools for thinking about them were valuable but secondary. Nice to know if someone happens to explain them, but nothing urgent. There might well be good reasons for teaching law this way, but a side effect is that most students never really gain the knowledge of the tools that ought to be the largest payoff of the enterprise. It is hard to see why the tools are valuable, much less to master them, unless you see lots of examples of how they make different areas of law easier to understand. But that only happens if the teachers of different subjects coordinate what they say. If the torts teacher explains how the prisoner's dilemma works in that area of law, and the contracts teacher explains it in contracts class, and the teacher of property law explains it there. This generally isn't done. Law teachers don't coordinate their efforts much, and they have different views about what's worth saying in class, so many of the best tools for thought are likely to be mentioned just once or twice during law school, or maybe not at all, and the student ends up never getting the hang of them. In effect, the tools become the property of an inadvertent cognoscenti. Nobody means to keep the ideas behind them secret, but nobody takes the trouble to fill everyone in about them either. The good stuff is hidden accidentally and randomly, some of it in a course over here, some of it in the library over there, perhaps in an article that not one law student in 1,000, and not one professor in 100, reads. And then there is all the work done outside the law schools by economists, political scientists, and cognitive psychologists that has value for people thinking about legal problems. The small share of it that would be of most interest to a student or to a generalist lawyer or law professor, the portion that amounts to a helpful analytical tool, or to an instructive or charming illustration of the use of one, is not always easy to find. This book is meant as a corrective to the problems just sketched. So far it might sound like an aid for law students, and it is indeed meant to help them. When new recruits ask me what they might read during the summer before law school, I never have been sure what to suggest. But it is also meant for others interested in law, whether professional or amateur. This is the book I would have liked to have read before I went to law school, when I understood almost none of what it explains. But it also is the book I would have liked to have read when I got out of law school, at which time I understood about half of it. It even is a book I'd like to have had at various earlier points during my teaching career, as when I wasn't sure about the meaning of a stag hunt or the conjunction paradox. Now, a few disclaimers. First, a book like this can only introduce tools for thought. There is more to say about each of them, usually much more than can be conveyed in a short chapter. Specialists on the subjects treated here will have no trouble finding imprecisions or omissions. But the goal of the project is merely to say enough about the tools to give you a good sense of their power and to get you started using them on your own. Second, I said earlier that this book tries to present in one place the most valuable tools for thinking about the law. Now I have to grant that the success of the effort is only partial, for there are plenty of important legal ideas that the book doesn't discuss. It is limited to tools for thought that lend themselves to this format, ideas that can be introduced effectively with a bunch of good examples in a short chapter. Some of the notable omissions include ideas from moral theory, from critical legal studies, and from legal realism. The last one especially hurts, since it is an area where I like to write. I don't discuss theories of constitutional interpretation either, because they don't have the kind of versatility that the other tools do. They don't illuminate lots of different corners of the law. Their value is confined to the area for which they are designed. Not coincidentally, they usually get covered pretty well in law schools, making treatment of them here less worthwhile. A danger in leaving out these topics is that the book might be viewed as disparaging them by implication. A large share of the ideas offered in this book are economic in their origins. This isn't meant to imply that economic or utilitarian approaches to law are the only valuable ones, a position I have argued against elsewhere at some length. I merely claim that they are very helpful and that they invite an introductory treatment of this sort. Everything will be fine as long as the listener kindly remembers that the book doesn't claim to be a complete collection of the helpful tools for thinking about legal problems. It purports to be a useful start. Finally, even among ideas that lend themselves to the format of this book, I am conscious of how much that I have left out. A chapter on textualism and alternatives to it was left on the cutting room floor, along with one about social norms. And as I prepare to send the manuscript to the publisher, I already am running across other ideas that I wish I had managed to include. But the book already is longer than it was meant to be, and I console myself with the thought that some of the omissions may become fodder for a later edition if the first one finds an audience. The book consists of 31 chapters grouped into 5 parts. The first concerns incentives, the effects that legal decisions have on the choices people make afterwards. The second part is about trust, cooperation, and other problems that arise when people work together. The third part takes up subjects from jurisprudence. It introduces some classic tools for thinking about how courts make decisions, rules and standards, slippery slopes, and the like. The fourth part, on cognitive psychology, discusses ways that people may act irrationally, or as Richard Thaler would say, quasi-rationally, and the implications for law. Last comes a part on ways to look at problems of proof that are common to many different legal subjects. The sorting of the topics into these bins is somewhat arbitrary, and they certainly can be enjoyed out of order. But the later chapters sometimes refer to earlier ones when there are connections to be made, so listening to them in the order given will probably be most satisfying. A final note at my copy editor's request. I sought to write this book in the clearest possible English. I naturally encountered the problem of choosing a pronoun to refer to someone who could be male or female. I dealt with this by treating the masculine pronoun as referring to anyone of either sex. I find the other, newer ways of handling the problem too self-conscious to bear. I know others have different views, and am sorry for the annoyance that my inclusive use of he and him may cause them. Part 1. Incentives. 1. Ex ante and ex post. A thief walks into a bank, puts a gun to the head of one of the customers, and announces that he will shoot unless the teller hands over all the money in the drawer. The teller does nothing. The thief shoots the customer, runs off, and never is seen again. The customer dies of his injuries, and his estate brings a lawsuit against the bank, complaining that the teller should have given the money — it was only $5,000, let us imagine — to the thief. What should the court say? There are two quite different ways to think about this question. The first looks at the case like this. It is a dispute between the bank and the estate of one of its customers. They've come to court because they haven't been able to resolve their differences informally. The judge serves as an adjuster of last resort, producing an answer the parties agree to accept because it has the force of law. One of them will walk away a winner. The question is who? We find the answer by looking back at what happened and asking whether justice requires that the bank pay damages to the plaintiff. Did the bank do anything wrong? If the teller's refusal saved the bank some money, would it be fair for the bank to pay nothing to the party who was injured as a result, or more precisely to his estate? Can the bank bear the economic burden of the customer's death more easily than his kin? We might consult our sense of fairness, and it might be possible to draw analogies to this case from others that seem similar. Perhaps cases where a customer slipped on a puddle left behind by the bank's janitor, or where a bank was held liable because one of its tellers tipped off a thief that a customer soon would leave the bank with a great deal of money. We could try to decide this case like others that sort of resemble it. That much is, again, a first way of looking at the case. But now here is a second one. What happened that day at the bank is unfortunate, but of secondary interest at this point. It's over, and nothing a court says can change what happened. Money can be moved from one person to another now, or punishments inflicted, but these are just rearrangements, and they are too late to be of any serious consequence. What's appalling about the day at the bank, or any crime or accident, is the waste of it. The lost life, the demolished car, the broken window, or whatever the harm might be. When any of those things happen, the world is made poorer, irrevocably so. This is intuitive and obvious to the family of the person who was killed. They are painfully conscious that nothing the law says can bring him back. But it's also true, if less obvious after an accident that merely wrecks a car. The car can be repaired, and whoever was to blame can be made to pay for it, and now the car's owner might feel that the law did bring back the car. A miracle. It's as if the accident never happened. But it isn't a miracle. It's a waste. No matter how satisfied the owner feels, the world would have been better off without the accident, because it ate up money that would have been better spent on something else. Anything else. Just ask the person who ended up paying for it. The point is that the law doesn't fix bad things that have happened. It can't. They've happened. All the law can do is redistribute the suffering a bit. That isn't nothing, of course. Assigning blame and making the right person pay for it might make the victim feel better, or make the rest of us feel better. But the law's dream, anyone's dream, would be to turn the clock back and stop the bad thing from happening in the first place. That would be much better than quarreling afterwards about who should justly suffer for it. Too bad it's impossible. Yet, in a sense, perhaps it is possible, for the court may be able to do something almost as good. It might make a rule that would cause horrible events like the bank robbery to be less likely from now on. This wouldn't undo the killing that already happened, but it could stop some killings in the future, and that's equally good, isn't it? Or better than equally good, for we would be stopping lots of bad things, not just undoing one of them. If they aren't prevented, we'll be just as unhappy about those killings after they occur as we are now about the one that already did. We'll wish we could turn the clock back, perhaps to today. So here we arrive at a different vision of what the law can do about a case. Instead of looking back and deciding who should bear the suffering, it can look ahead and decide what ruling will make the suffering less likely to occur later. What would this train of thought look like? In the case of the bank, it means asking what incentives people will have after the case is over. Here's an interesting possibility. If the court says that the plaintiff wins, then from now on banks will have an incentive to hand over the money when thieves take hostages, to avoid paying in court again next time. And that, in turn, means that thieves will have an incentive to take hostages. True, thieves might not know the legal rule, but then they might not need to know it. Maybe they would just observe that taking hostages has become wonderfully effective. The teller always hands over the money. The trouble becomes apparent. Letting the customer's estate win might cause more hostages to be taken in the future. Perhaps fewer of them would be shot, since the thieves would get the money they demand, but it's hard to be sure what will happen once guns have been drawn and hostages taken. On this view, the bank has to win the case brought by the customer's estate. It's not a question of what's fair as we look back on the fateful day. It's a question of making the right rule for the future. The bank has to win for the same basic reason that governments won't give in to hijackers of airplanes when they demand money or whatever else. It's tempting to make the payment and save the passengers' lives. You probably would make the payment if you knew it was never going to happen again. But that's the point. Not just that it might happen again, but that if you make the payment, it becomes more likely that it will happen again. So now we have heard two distinct ways of thinking about a problem. The first can be called the ex post perspective. It involves looking back at a disaster or other event after it has occurred and deciding what to do about it or how to clean it up. The second perspective is called the ex ante point of view. It involves looking forward and asking what effects the decision about this case will have in the future on parties who are entering similar situations and haven't yet decided what to do, and whose choices may be influenced by the consequences the law says will follow from them. The first perspective also might be called static, since it accepts the parties' positions as given and fixed. The second perspective is dynamic, since it assumes their behavior may change in response to what others do, including judges. Part of what makes judicial decisions interesting is that courts think in both of these ways when they decide cases, and the two styles of thought can point to different conclusions. Does a court's decision settle the dispute between these parties, or does it make a rule for others in the future? It almost always does both. This chapter, and much of the rest of this book, emphasizes the ex-ante perspective because it creates lots of interesting possibilities for thought and argument, and because it usually comes more slowly than thinking ex post. It's only natural to think in an ex post fashion when a lawsuit comes up. Here are two parties in a vigorous dispute, perhaps blaming each other for a disaster. Their attention is fixed on the past and what should be done about it. They don't care what effect the decision has on others down the line. They just care who wins right now. That's especially true in a case involving a random accident. The bank in our example may be a little different. It may be worried both about winning the case and about the rule in the long run, because it deals with these situations repeatedly. But the court has to care about both perspectives, for it will be declaring a winner now and making a rule that affects others later. In fact, most courts to consider the problem of the bank teller have found in favor of the bank on the ex-ante grounds sketched a moment ago. The Illinois Supreme Court put the point like so. In this particular case, the result may appear to be harsh and unjust, but for the protection of future business invitees, we cannot afford to extend to the criminal another weapon in his arsenal. In other words, the argument from the ex-ante perspective won out over the ex post. The practical challenge is to learn to see that sort of argument every time it's available. To learn to think the ex-ante way when a case is full of cues tempting everyone to only look backwards. The simplest way to find the ex-ante angle is to picture either side winning the case, and then imagine how the parties will think a week later, what either of them might do differently now that they know how the courts will respond. Thus, you can imagine the bank learning of the decision and changing its rules to make sure that its tellers hand over the money, and then you can ask how this would in turn change anyone else's incentives, starting with the thief. In real life, of course, the parties whose incentives we care about the most probably aren't the ones before the court. This bank, that thief, and so on. We're worried about banks generally and thieves generally. But sometimes it helps to think concretely about the parties you can see and then try generalizing to the ones you can't. Another way to come up with ex-ante arguments is to imagine how a legislature would think about the problem facing the court. Legislatures make general rules for the future. They don't resolve individual disputes that have already occurred. So, if a legislative committee or a government agency were considering a rule about how banks should handle hostage takers, it less likely would be distracted by the equities of any one case. Its role would be to make decisions that have consequences ex ante, going forward. Granted, a court isn't in quite the same role. It is supposed to decide cases according to the authorities on point, statutes, case law, and the like. And in the case of the bank teller, that is where a real court would start its search for an answer. But it often happens that there are no authorities entirely on point. In effect, a judicial decision then serves as a little piece of legislation as well as the resolution of a conflict. The balance between these two functions varies among courts, and students of these matters often argue about how the balance should be struck. But judges at most levels of the legal system accept the importance of giving at least some thought to the ex-ante effects of their decisions, as do the lawyers who make arguments in their courtrooms. When you hear that a lawyer is making a policy argument, that usually means it's an argument from the ex-ante perspective. That is, a claim about the effects the decision might have on someone's incentives. Let's go over some other examples. I build a house. Unfortunately, I was mistaken in my measurements, and the structure extends onto your neighboring property by 18 inches. There is no cheap way to correct the problem. Either the house stays where it is, or much of it will have to be torn down. What to do? The ex post style of thought accepts the situation as it is and asks how it might best be resolved. Nothing the court says can change the fact that the house encroaches. All we can do now is try to keep the damage caused by the mistake to a minimum. So the natural remedy might be an order that I pay you for the strip of land I built on, perhaps with a little premium since the sale is, in effect, being forced on you. Why waste a perfectly good house by tearing much of it down? But the ex-ante perspective is entirely different. On this view, it matters little how our particular mess gets resolved. The important question is how the resolution of it will affect our behavior in the future and the behavior of others like us. From this standpoint, an award of damages, a forced sale, might seem a terrible solution. It deals sensibly with the problem we already have, but it doesn't give me or anyone else an incentive to be more careful next time. Indeed, it might create the opposite incentive. If I wanted to build on a bit of your property, but were unsure whether you would be willing to sell, my best plan would be to go ahead and build and then let you sue for the value of the land. Even if I have to pay a premium, I still might be better off this way than by negotiating with you. So the usual rule in encroachment cases is that the plaintiff, the complaining neighbor, gets an injunction entitling him to insist that the house be removed. There is more to say about this case, and we will return to it in other chapters. For now, the important point is to see that it's another win for the ex-ante perspective. Ex post, after the thing is done, having one neighbor pay the other might seem attractive. Ex-ante, thinking about the incentives for next time before anything has happened, payment of money seems decidedly unattractive precisely because it makes the bad thing more likely to happen again. Notice the analogy to making the bank pay damages to the hostage's estate, which might cause the number of hostages to increase. And notice also that the ex-ante point of view is more than just a useful tool for courts to use in deciding cases. It's also important to remember when deciding more broadly how well a rule works. A rule requiring buildings to be torn down when they encroach might look ugly if you just study the cases where the rule actually gets used. All you would see are buildings getting torn down or neighbors demanding extortionate prices from each other to avoid that result. But the consequences of the rule don't appear only in those cases, or even primarily in those cases. The results of the rule also include all the cases where the building never encroaches in the first place because everyone was careful to get a proper survey done, for fear that otherwise the house would have to be torn down later. So new houses that don't get torn down are evidence of the rule's operation too. A rule that looks brutal and wasteful when invoked might actually be working beautifully, if invisibly, by causing the occasions for its use to be rare. These same trade-offs arise often when courts decide whether to allow evidence into a case. A police officer sees a fellow with a butcher knife chasing someone out the front door of a building. The officer shoots and kills him. Or at least that's what she says happened. The trouble is that no knife was found on the dead man afterwards. The officer has some sessions with a therapist to discuss the incident. Meanwhile, she is sued by the estate of the man she killed. The plaintiff demands to see the notes the therapist took during the sessions with the officer. Should this be allowed? Ex post, now that the notes exist and the two sides are arguing about them, the answer might seem clear. Of course the plaintiff should be allowed to have them. They might show something important. What if the officer privately admitted that the story about the knife was an invention? What if she admitted that she shot the man because she had a grudge against him? Surely the jury ought to know those things. And if the officer didn't say anything incriminating, what's the harm in finding out? All this might seem a little unfair to the officer if she thought she was speaking in confidence, but that interest pales in comparison to getting at the truth behind the killing, does it not? To repeat, however, this whole line of reasoning starts by taking for granted that the notes exist.
Sample complete. Ready to continue?